This is what we've got in the Court of Appeals of Virginia. Amber Laura Heard versus Johnny C. Depp. Opening brief of Amicus Curiae in support of appellant Amber Heard and reversal of the judgment. Okay, so an Amicus Curiae is a friend of the court. This is a friend of the court. They say, we are not an interested party in this case. We are coming as a friend of the court to make some points of law or some sort of argument based on what happened, because even though we're not a party to this case, we feel that the repercussions of this decision may impact us. And they're supposed to approach the court as a relatively neutral player. Hey, we're just a buddy, trying to give you some advice. But they're always in support of one of the parties and one of the parties' positions, most importantly. And that's what they'll say. They're in support of a position. But oftentimes you'll find that they're just in support of a party, because of course they are. Why else would you take the time to do this? Oh, sometimes you could be not in support of a party, but in support of the position, still think that the outcome is really important. Those are the purest amicus briefs, and they do happen. But that's what an amicus is. So this is their table of contents. When you're writing, different levels of court have different levels of writing expectations, different formatting requirements, and different needs. Frankly, different things you need to do. Here's your table of contents. You don't have to have a table of contents in any brief at the district court level, but it's helpful in every brief. It's a really nice way to organize the document for the court and the court clerk, remembering that a lot of this stuff is actually read by the court clerks first, or the judge's clerks first, and the clerks kind of highlight and make recommendations for the judges to look at, because judges are very, very busy. Very, very busy. They read through a shitload of documents, and having some bullet points from their trusted hired aides is really helpful. And so if you're out there, if you're a lawyer, if you're writing briefs, let me just offer a piece of friendly advice. As someone who has spent a lot of time reading these fucking things, writing a table of contents is it's really helpful. It's really good writing, and it's a good practice, because if your document looks clean, the judge will pay more attention to it. Table of authorities. This is just going to be a reference guide for all of the cases that are cited and what page they're on. Identity and interest of amicus curiae, why they're writing this brief. Source of authority to file. This is, where they have their reason for filing. So the introduction, summary of argument, and then they're going to have their conclusion. This is called the, basically, it's a basic IRAC format. So you have your intro is I. RAC is the rule typically, but they're going to have the rules in each of their argument points. And then you'll have your argument and your conclusion, IRAC. This is standard legal writing. Good stuff. Here's their table of authorities. We don't need to go through that. Table of media publications that they're going to cite as secondary authority to support their stupid position. Identity and interest of amicus curiae. The entities identified in Appendix A who have signed onto this brief fall into three primary categories. First, organizations that support a vibrant First Amendment have joined to protect their ability to engage in reporting facts and opinions regarding important current issues. And this is often the cry of the defamation, the cry of the defamation defendant. Well, I had a First Amendment right. I had a First Amendment right to defame someone. Well, you don't. That's not First Amendment protected speech. Lying for the purpose of harming someone's reputation and economic ability is not actually an exercise of free speech. It is an exercise of assault. It is damaging. It is harmful. It is intended to harm. And Amber Heard's statements about Johnny Depp were unquestionably intended to harm him, because they were false. She knows they were false. And they did, in fact, cause significant amounts of harm that she was hoping to cause. She wanted him out of work. She wanted to benefit from his harm for herself. She wanted to gain from his loss. That was the entire purpose of making all these statements. We all know that. She knew it. The jury knows it. Everybody knows. There's no First Amendment defense to intentionally lying to harm a reputation. That'd be like saying you have a right to travel while driving your truck through someone's house. Well, I have a right to travel. It's like, well, yeah, but your right stops at their property line. The same goes with free speech. Your right to free speech stops so long as that free speech is untruthful and intended to harm, which is threatened by the verdict in this case. So that's, again, engage in reporting facts and opinions regarding important current issues, which is threatened by the verdict in this case. Actually, it's not, because the people reporting facts and opinions around this are not sued for defamation. Only the defamer, who is Amber Heard. Amber Heard defamed Johnny Depp. She used the Washington Post opinion section to do that, but Amber Heard's the one who actually made the statements defaming him. She's the one who's liable for the defamation. Second, civil rights and women's groups have joined to address the significant diminution of reporting of abuse against women as a result of this verdict. Here's the problem with that one. Let me say this loud and clear. Too fucking bad. I'm sorry. No. This is critically important here. The greater zeitgeist conversation around an issue is subservient always to individual rights. Do you hear me, you fucking losers? I don't care if one murder acquittal makes every murder more likely. That person's individual rights are more critical than everything else, because this country was founded on the notion of the smallest minority having primacy over everything else. And the smallest minority is the individual. And the fact that these fucking losers want to conflate an individual's right to not be defamed by an insufferable bint with some greater conversation about abuse, they can get fisted all day long. Fuck them forever. Forever. This is reality. The collective is always beneath the individual. Always, always, always. Otherwise, you have some communistic pseudo-socialist bullshit running our lives. And no, thank you. I don't want to go to prison or have my life ruined on the altar of some greater movement. And I don't think anyone else here does either. And if any one of these people went through it, as we've seen with every one of the Me Too people who are at the top of that organization resigning when their brother, son, husband, or anyone around them got Me Too'd, and they're suddenly like, well, I guess we don't want to believe all women. That was a shitty policy, wasn't it? Well, it's amazing, isn't it? The second that their individualism is threatened, they run for the hills. Because of course they do, because it offends the sensibility of anyone who knows what individualism means to think that that should be sacrificed on some greater altar of some social movement. Fuck off. Third, groups assisting persons who have been abused, especially involving intimate partner abuse, have joined to protect their clients from the devastating effects of this verdict. Hey, if your clients don't lie, there's nothing to worry about. Now, let me do this again briefly. There's an important distinction here. There's an important distinction with all of this. Amber Heard is a terrible poster child for protecting abuse victims. Not only was Amber Heard lying about the abuse she received at the hands of Johnny Depp, and that was clear from the factual record that she was lying about it. So not only that, but also, she was the abuser. And that's documented all over the place. That, and part of the argument that we're going to get to in this amicus brief is that any of these things are abuse. Okay, well, if we take your perspective that any of these things are automatically by definition abuse, then there's tons in the factual record to support Amber Heard is at least a mutual abuser to Johnny Depp. And that's only if we accept all reports from everybody as equal and equally credible, which they are not. The reports supporting Johnny Depp as an abuser were weak, not corroborated, do not have a strong factual basis, don't have good photographic evidence of results. The reports of abuse from Johnny Depp by Amber Heard, so Johnny Depp being abused by Amber Heard, those reports are corroborated by multiple witnesses. There's photographic evidence of damage done to him that links tangibly and reasonably to the stories he says. You can hear it all over the place from people who witnessed this. Those things come through and we go, oh, okay, there actually is corroboration on this. Her being the abuser is actually kind of the normal expected thing. That's the thing we've come to know about the relationship. So suggesting that victims of abuse need to be protected from this devastating effect, no, because the victims of abuse are not often also abusers or actually the only abusers. That's not the normal case. That's the Amber Heard case. And it's baffling to me. It's baffling to me that we're continuing this charade that Amber Heard was the abuser. But where I'm getting to with this is when you're supporting an amicus brief or you're trying to take a case to appeals for like a greater cause. Now, Amber wants to appeal this because she's 10 million in the hole, right? Maybe she'll have to use her hole on OnlyFans to make that 10 million. I don't know. But she's 10 million in the hole here. So she's like, I got to get this thing appealed. These other organizations are not in that boat. They need to pick a proper plaintiff, a proper appellant to make their case. And Amber is a shit appellant. She's garbage. Her case has always been bad. You always want to pick a good, favorable appellant to make your case, because if the appeals courts kind of look at this and go, yeah, but wasn't she like beating him? Didn't she hit him and scratch him and shit on his bed and piss in his face or whatever? Like, didn't she set up some of this stuff? Didn't she use two of the same picture to try and make out like those are two different events? Didn't she lie on the stand a whole bunch? Didn't her therapist say that like the Goldwater rule was not valid and that you couldn't have expert witnesses with the Goldwater rule, even though we've had that forever? Like, didn't all these things happen? Maybe we want a different case to take this one. Okay. In addition, respected authorities in all three areas that added their voices to the brief. I doubt it. Source of authority to file. Amici have moved for leave to file this brief in the accompanying motion pursuant to Supreme Court of Virginia Rule 5A23. So here's their rule on why they can file the brief. I mean, usually amicus briefs are, once you get to the appellate level, they're relatively welcome. Introduction. Amici are gravely concerned that the verdict for Johnny Depp versus Heard case against his former wife, Amber Heard, casts an enormous shadow over First Amendment law, intimate partner abuse victims' incentive to report abuse by their attackers, and the ability of Americans to speak out about injustices. Wrong first sentence. Terribly incorrect first fucking sentence. Your first sentence of your amicus brief. Okay, let's lay out what they're facing here. Let's lay out the important part. This is an amicus brief for an appeal to overturn a unanimous jury verdict. A unanimous jury verdict. Okay? That means that 7 people in Virginia listened to all of the facts and evidence. They listened to all of it. They weighed the credibility in their own minds of the witnesses, of the exhibits, of everything. They listened to the opening and closing arguments and they went, bam, this is how it should go. We listened to all of it. The appeals court didn't. Now, they may have on their own, but they didn't, and they won't. They were not there to assess the credibility in the room. They're not there examining all of the exhibits. They're not in the jury deliberation room talking about what everybody saw. They're not there. So they can't have made these decisions. And they often trust the people who did. That's how appeals courts work. They defer to the district court on matters of evidence unless there's a clear error about a ruling on evidence. That does not mean when evidence is in, though, when it's in, unless there's a proper objection to it coming in and they review that and they find the objection to be correct and that the district court made an error. Once the evidence is in and that's not the objection, then they accept that evidence as real and they accept the assessment of credibility of that evidence given by the jury as real 99% of the times. That's what they're going to do. So your opening statement can't appeal to this bullshit about First Amendment law, intimate partner, abuse victims, incentives. Your opening statement in an amicus brief says the evidence in this case clearly indicates that Amber Heard was a victim of abuse, that Johnny Depp was the abuser, and that the jury verdict is legally incorrect and unsustainable. That's where you need to go. Open up strong. They're trying to overturn and invalidate the jury verdict, and they haven't actually attacked it. In your first line, the one thing you want this panel of judges to be reading this and go, okay, the perspective is the entire jury was incorrect, that they were legally hoodwinked, they misapplied fact to law, and we got a bad verdict. All right, now they're going to tell me how. Nope, they're appealing on notions. I'm sorry, notions don't apply to individuals. Period, period, period. If the individual's First Amendment rights are impacted, then you lead with that. Amber's weren't. If the individuals are victims of intimate partner violence and that all of the evidence pointed to that, and here's the standard. No reasonable jury could have come to the conclusion that this jury did, implying de facto that this is an unreasonable jury. Until you do that, and if you don't establish that, you lose. You lose like Willy Wonka. Good day, sir. Get out. And their opening statement is the most limp-wristed bullshit I've ever seen. What are you doing? Come the fuck out. Guns blazing, dicks spraying. Why would you do this? If not reversed, this verdict, listen to this if not reversed, this verdict will have profound effects on the jurisprudence of the Virginia. Oh, okay. And further effects on the ability of women nationwide to stand up to their abusers. None of that matters. First of all, the Virginia, you've got a typo in the second line of your brief. The second line. You're not 30 hours into this brief. You're not in the last pages. You're not dying to meet some sort of deadline. What the fuck are you doing? Proofread a little bit. But second, the effect of women to stand up to their abusers nationwide does not matter. This is a jury verdict. We went to court on the individual facts, not on the notions of what other abuse victims with other factual scenarios will be able to do and say. It's also bullshit, by the way. Johnny Depp doesn't do anything to any abuse victim ever because we're talking about two of the top 0.001% people on earth, the highest income earners, the most famous, the prettiest people around, and I don't mean, I should say beautifulest people, right? Like Marilyn Manson. These are high society folk. This doesn't apply to average abuse victims in any way because average abuse victims don't lose $100 million contracts over these abuse claims. It doesn't happen like this. Average abuse victims don't get op-eds written in Washington Post that slam their purported abuser and get him removed from an entire industry. If an average woman wrote the same op-ed that Amber Heard wrote, her husband's not getting fired. The verdict will have a chilling effect on a wide range of commentators. How? How are you going to do this? How are you going to make this point when no commentators have suffered negative repercussions? No commentators have had negative repercussions of this. First of all, the only commentator who was sued for this was the UK Sun in the UK, and they won. They won. The commentators won on this, and that would go right in my brief. My reply to this thing will be actually all the commentators who were sued in this won. They were in another country that doesn't have the First Amendment and their rights were preserved. Why any commentator would think that their reliance on Amber Heard's statements would be somehow defamatory when none of them were sued for it in the US and the only one who was sued in a country with even less freedom prevailed is baffling and nonsensical. That'd go right in my brief. These people are actually would say these people are fucking stupid. Specifically, the verdict has already and will continue to deter women who have been abused by their partners from reporting such abuse, whether it be, among others, mental, psychological, verbal, physical, emotional, or sexual abuse. They actually cannot verify this. And this is always the trick when you're talking about legal documents. You'll notice something in legal documents. They have citations to fucking everything all the time, right? Boom, boom. Footnote citations, regular inline citations. You should never do this, in my opinion. Either have your footnote citation. Well, I guess they're going to do inline citations and footnotes for expository points. So I guess that's an okay writing style. I'm not a huge fan, but that's fine. So if they're going to do this, they'll have a citation for everything, especially bold claims like this one. But notice what's missing. There's no citation. Where's the study? Where's the study? Where's the study, fuckers? Where's the data? You're telling me this big claim, this has had a profound impact on women's ability to report intimate partner violence. Oh my God, we got to act. Where's the study? Where's a news article? Where's one person? Where's an affidavit? One affidavit of someone saying, I wanted to report intimate partner violence against my spouse, but I didn't because of Amber Heard versus Johnny Depp's verdict. Where's the one? Can you find anyone to substantiate this? No, this is just a baseless and empty claim. It's also going to be ignored by the court because of course it's going to be ignored by the court. They don't give a shit about your sob story. This whole amicus brief is something called a public policy appeal. And this is always your weakest point. Now, people have won on public policy, but that's when it's a public impacting decision that really fucking matters. And the public policy is well established. This isn't a well-established public policy. Perhaps cynically, perhaps ridiculously, we could say it's not actually well-established public policy that the United States or individual states have an interest in protecting women reporting domestic violence. And all of these fucking dummies signing on to this believe that in their core, in their balls, in their lady balls, they believe this. They're like, well, no states support this. Well, it's going to be hard to make a fucking public policy argument if it's obviously not the public policy and every word you spew onto the page drips with the fact that you disdain the current public policy. But you're going to try and make the argument that it is public policy. This is a loser of an argument. It's a loser of a brief. It's a loser of a case. This is all obvious, but this is true. Don't make this claim without a fucking citation. And you can get one. You could get anybody. Certainly, these people who represent women who have been abused, certainly they could find some woman to just lie at least and say it, or just hold off on making some public statement. Just say you're afraid to do it. Just say you're afraid and write your name on the line and we'll cite to your thing and you will be supporting women everywhere through your statement. Oh my God, so powerful. It's good. That's all you have to, anybody. One Mother Jones, they're going to cite Mother Jones here as if Mother Jones has any credibility in any circle anywhere and isn't just the fucking rag that communist women use to rub their period blood on. What the fuck are we talking about? Mother Jones should never be in a legal brief unless it's parody. Not only was this a highly publicized trial, but it became a social media sensation, possibly in a manner that was not wholly organic. Oh, here we go. Back to the bots did this. Bots did this. The most... Just fucking think about this for 1 second. For 1 second, can we rationally think about this? Top 10 most famous people on earth, Johnny Depp, gets sued by top 1,000 most famous whore Amber Heard. Possibly not organic sensation. Oh my God. Oh, okay. Sure. That's right. One of the most popular in the US and probably worldwide people on earth has a lawsuit over a career that was destroyed 4 years ago, notably and publicly demolished. And we're like supposed to pretend that this was supposed to pass like a fart in a tornado? No, yeah. No one knew it was coming. No one would have been talking about this if not for the bots on Twitter who ginned up a bunch of stuff. Oh my God. And Amber Heard's only in that high list of famous people because of her attachment to Johnny Depp. Let's be very, very clear on this. It's like Mackenzie Bezos. Everybody knows who Mackenzie Bezos is because of Jeff Bezos, not because of Mackenzie. The fuck cares? But she's attached to an extremely notable person. And that makes her automatically more notable than she otherwise would be. Amber Heard is a pretty woman. She's not the hottest chick ever. I mean, let's not lie though. Amber Heard was pretty fucking smoking when she was younger, but she's still pretty now. But Amber Heard's a pretty woman who is a low mid-tier actress whose value is quickly running out as age sets in because she never bothered to harbor the talents of acting. She cashed in on her existing sexual capital very early. Good job. I firmly and strongly recommend women, especially young women, to exploit their sexual capital wherever profitable. I'm not saying go be whores. I'm not saying do porn or whatever. I'm saying utilize those advantages while you got them. Of course. However you're going to do that. If you're getting free coffee because the barista is like a super hornball, get your free coffee, ladies. I support it 100%. Whatever you're doing, use that capital while you've got it to its maximum effect to your benefit. Fantastic. But while you're doing that, my God, develop the necessary skills to persist when that sexual capital goes away. And it goes away for everybody. It's not personal. It's not you. That's just how it's going to be. So develop some fucking skill. And Amber Heard has everything. You have a fantastic acting coach in a husband. You're surrounded by some of the best actors and actresses. You have access to all of them. You have the best acting coaches around, like at your disposal. You have unlimited resources. Develop your fucking talent for just a moment. Spend a second making yourself marketable beyond the wall. But no, instead, sniff those drugs, Amber. It is a common tactic for an abuser to sue their victims for defamation. It's actually not a common tactic. It's not common, but I guess most abusers don't sue their victims for defamation. I just want to point that out there. Let's say it again for those in the back. Most abusers do not sue their victims for defamation. Re-traumatizing them and impoverishing them through the legal system. Sure. Okay. This problem only worsened during the Me Too movement. Oh yeah. We saw a lot of retaliation on the Me Too movement. Yeah, tons of people were just out there not tucking their balls up into their assholes and praying to fucking God that they didn't talk to the wrong chick at a bar. Yeah, that wasn't what was going on during the Me Too movement. What was actually happening was men suing their accusers. Remember the notable case of when that one person sued their accused victim? Remember that? That one, you remember? You remember that one though, right? Like during Me Too, like back in 2018 when Me Too was super popular. Remember the one that no? Was it the other? Yeah, I don't really remember any. I remember a bunch of dumb motherfuckers trying to make public statements and weather the storm that way. We saw them where they ended up. Prison, destroyed, removed from their careers, completely fucking baffled and, and demolished. Like all of that. Yeah. Oh, that's right. That's right. Oh my God. This problem only worsened during the Me Too movement, and this tactic has accelerated due to the verdict in this case. Okay, now, see, here we go. This line actually undercuts this one because this one has a citation. Johnny Depp's legal playbook won't work for most men. Wait, why? 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 No, why? Why would you do this? Why would you cite? You're like, this tactic has accelerated due to the verdict in this case, and the title is Johnny Depp's playbook won't work for most men. So why would it accelerate? What evidence does this show that this is accelerating? My God. Now, the clerk is probably going to go breeze through this article, but the titles fucking matter. The titles matter. The title of this one says it won't work for most men. Oh, yeah, that's very convincing that this is definitely going to be a legal playbook that's used by everybody. Lawyers have noticed a substantial increase in defamation cases involving domestic violence and sexual abuse in recent years. Okay, where's your citation for this? 1. 2, recent years has nothing to do with a 2022 verdict. So how is this supporting your case? How does this matter? Tell me why I believe you. Just give me any reason. Just one reason to believe you. And they don't. 2022, the verdict comes in, what, in July, June, May? I don't know when it was. May. It was either May or June, I think. The verdict comes in for Johnny Depp. And we're talking about an increase in defamation cases in recent years. You just told me that Johnny Depp didn't influence it, but everything else did. Maybe it was the fucking plethora of bullshit lawsuits. Maybe that is why you're noticing an increase in defamation, because there was a social movement called Me Too. Maybe it was called But Not My Vagina. I don't know what it was fucking called. The Me Too movement came up with so many frivolous accusations supported by clinger on dick rider accusations where someone goes, oh, someone accused somebody? Oh, yeah, I met them in an elevator once and they sniffed after I farted out of my pussy. Therefore, they're a sexual abuser. And the person's like, bitch, I don't even know you. Who the fuck you is? And this shit happened to some of the most powerful and prominent people in the industry, and they got chopped the fuck down like a redwood on Christmas. I don't know how that analogy works. Trees, holiday, the analogy works. But they got chopped down like nothing. Their millions of dollars meant nothing. The amount of fucking social credit they had built up meant nothing. Nothing in the hands of Random Woman 63. Random Woman 63 is more powerful than anyone in Hollywood ever was. And it's crazy. Like, that's an insane thing to say. Some bitch who you can't even verify was in the same room as the person became more powerful than a multi-millionaire for a period of about 2.5 years. And so all of that happened, and we saw more lawsuits. Yeah, well, we saw more public accusations of people with money to fight lawsuits. What do you expect? But the funny thing is, that's what they just told us. They didn't tell us anything about the Johnny Depp trial. Between 2014 and 2020, there were at least 100 defamation cases filed by those accused of sexual misconduct. All right. That's a 6-year period before the 2022 verdict. So what happened next? Most of which were filed after the Me Too movement began. Okay, this is irrelevant. This Mother Jones argument or article is completely irrelevant to this case. What are we talking about here? 2020 is 2 years before the verdict. Focus, motherfuckers. Why can you not just make the argument? Oh, that's right, because your argument is shit. Quoting Mother Jones, citing Defamation and Darvo, Journal of Trauma and Dissociation. So then they've got a parenthetical describing it. Equality Now, a rights organization, similarly reports seeing a worldwide increase in perpetrators filing defamation lawsuits against victims of gender-based violence. While the trial of this case was incredibly invasive into Ms. Heard's privacy, fuck your privacy. You make public accusations, you don't get privacy anymore. It's gone. It's over. It's done. You have publicly accused a public person. What the fuck privacy do you expect ever again? It's you asked for fame. The internet will give it to you, milady. But with that comes a really intrusive look into who you are. And trust me, as someone who's on the internet calling people dumb fuckers all the time, an invasion of privacy, your privacy is invaded whenever the internet wants to invade it. You don't get it anymore. You're done. You're public now. As if Amber Heard wasn't public before, but you're public now. And that's the price you fucking pay. You want to get rich through popularity and publicity? You don't get to truncate the publicity to just tailor the amount that you want. It doesn't work that way. Ask anybody who jumps into this. You have to fight tooth and nail to protect your privacy, and you'll fail every time. You can't. You can delay things a little bit, and that's it. But your privacy's gone. You gave it up. You asked to be public. You asked for it. The argument of Mr. Depp's counsel to the jury relied upon many assertions that are nowhere within the four corners of the editorial at issue or reasonably derived therefrom. False. False. Johnny Depp's team did an excellent job of bringing all of Amber's statements about him prior to the publication into the publication. And Amber Heard helped them. She helped them the entire time. The jury, of course, is going to consider all of the shit that went into that publication as part of the publication, because the publication specifically called back to her public calls of domestic violence. To the at the ACLU, the fucking Downs lawyer who decided to try and help Amber Heard avoid a defamation trial by crafting her statements very specifically. You are the dumbest fucking idiot on the planet, and you should be sued right along with her. You're the dumbest person. What lawyer would advise her to call back to a specific time with specific statements that were made about a specific person in her very generic op-ed? Your job was to keep her from this lawsuit, and you couldn't do the most basic bitch legal advice of saying, maybe don't specifically reference a set of statements you made 2 years ago that led to the destruction of an individual. Maybe just not that. Maybe anything else. Maybe all over the place. Maybe don't give a specific timeline. Say, hey, I have decided to become an advocate against domestic partner violence. Boom. There. You just say that. Instead of saying, because of my past experience that I openly and publicly stated, I became this. No, just say you did it, because you don't need to be abused to be an advocate against domestic partner violence. Here we go. I, Nick Rekieta, have never been abused in my lifetime. I don't have scars or slap stains or dick whips or anything on me. I'm a perfectly happy and healthy, normal human being who is not abused. And I am standing against intimate partner violence because I think it's fucking bullshit. There we go. Done. I don't need to harken back to the halcyon days of getting my ass fucking beat to try and engender support. But she did. She did. And why did she do it? Not because she needed to build credibility, because a woman never needs to build credibility to be against domestic partner violence unless she's an abuser, but no one knew that about Amber at the time. A woman doesn't need to do this. A woman coming out and saying, I'm against intimate partner violence, says enough by itself to say that. You don't have to build the credibility. The only time you want to build credibility is if you want to fucking jerk that grift all over your whore face, Amber. That's what you wanted to do. You wanted to semen money all over you. You know you did. Of course you did. That was the point of the article. You wanted to tear someone down to build yourself up. And it happens to so many people. But guess what? When you do that, you're going to call back to some bullshit and you're going to get checked and you're going to get fucking clapped. And you deserve it when you do that. And the ACLU idiot who advised you that this is a good idea should take a 9-iron right to the fucking vagina. It offends me to see people give this shit tier level of advice. Like, your job was to protect this woman from her own dumbass, and you couldn't do it. You didn't do it. Instead, you're like, whoa. This is the ACLU. They know all about the First Amendment. They know all about the lines that you have to walk, and they couldn't fucking do it because they were jerking off too hard at the idea of fucking over Johnny Depp. The defamation by implication doctrine has been so unduly expanded in this case. It wasn't even expanded. I don't think it was even defamation by implication. I think it was straight defamation, personally. That it will lead to numerous meritless attacks on editorials and other publications that claimants will assert contain implied references regardless of how dubious the implication. But that's not what happened here. That's not what happened. They didn't sue the editorials and other publications. In order to find Ms. Heard liable for defamation by implication, a court must make numerous leaps of logic that are not justified by the actual words of Ms. Heard's op-ed or the reasonable implications therefrom. Here's the thing. They don't actually, and this is the easy out for the appeals court. Never give the appeals court an easy out. But the easy out for the appeals court is the jury found defamation, not necessarily defamation by implication. We don't know the distinction that the jury made. Defamation by implication is a way to defamation. And it's a valid way to it in Virginia, by the way. But we also could have just found that her statements were inherently defamatory. We don't know. But they've made the assumption that it is this. A court must make numerous leaps of logic that are not justified by the actual words of Ms. Heard's op-ed or the reasonable implications therefrom. I mean, they are, though. They clearly are. The reasonable implication is that, oh, by the way, my 2018 statements about him being an abuser are what matter. That's the implication. And of course, that's what she fucking wanted. Of course, that's what the ACLU wanted. Of course, that's the point of all of this. The implication is very fucking clear. Always has been. Requiring victims to defend against such lawsuits without proper First Amendment protections will cause speakers to either choose not to speak or to incur significant costs, usually against litigants who have far superior assets. Wait, based on what? Why do litigants have far superior assets? Why is that usual? It's not actually usual. That's this case. Depp has superior assets to Amber Heard, but Amber Heard had significant assets going into this case. She lost a lot of them. But again, she has all the First Amendment protections on earth. You don't have a First Amendment protection to lie about someone else to cause them harm. Or to cause you benefit. The publication at issue, Washington Post op-ed. Okay, now we're in the facts. Now we're in the actual argument. On December 18, 2018, Washington Post published, first online then in print, an editorial written by appellant Amber Heard with the assistance of the ACLU. Turns out, actually, the ACLU wrote almost all of it. And her own private counsel. Amber Heard opinion, transformative moment for women, blah, blah, blah. Ms. Heard had been invited to become an ambassador by the ACLU And so they were relying on her statements, by the way, and to work with the ACLU on an op-ed to bring attention to gender justice issues. Now we got 3 and 4. The online version sported the headline, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change, which is the basis of one of the 3 defamation claims. Yep. The evidence in the record showed this was a headline written by a staffer for the Washington Post, and Ms. Heard testifies she never saw the headline prior to its online publication or any time prior to the filing of the lawsuit. They didn't believe the testimony. And again, just because someone testifies something doesn't mean it's true. It means it's admitted into evidence. But the jury is the fucking determinant for the credibility of testimony. Amber Heard tweeted the fucking online article and she wrote about the article. Are you telling me you're going to honestly sit here with your thumb in your ass and tell me that Amber Heard did not read the headline that popped up when she put that fucking link in her tweet? Of course she did. Of course she knew about the headline. She's lying about it. It's obviously a lie. She wrote about it. She didn't just hit the retweet button and walk away. She hit that quote tweet. She wrote about it. It was right in front of her. She lied. The jury went, smells like a lie. It's fucking stupid. It's ludicrously unbelievable. All right, here. There was no contrary evidence introduced on the issue. The contrary evidence was just Amber Heard's credibility. And this is critical. Just because contrary evidence let me make a distinction. This is really important. This is not a summary judgment argument. A summary judgment argument takes the facts on the record. No credibility, no weighing of facts and evidence, nothing like that. Summary judgment is a cold look at what is asserted factually. An appeal of a jury verdict must consider that the jury saw the evidence and disagreed with you. This footnote is a summary judgment article or argument. Summary judgment argument. This is improper in an appeal of a jury verdict. It's not a winning argument. It's actually a shit argument. Because all the appeals court has to do is say, yeah, well, we will defer to the fact finder, the jury in this case's assessment of the facts and evidence presented in the case. They could have found it non-credible, unimportant, outweighed by other evidence, any number of things. We'll never know. We'll never know why they did it, but we only know that they did it. As the footnote 4, as the ACLU has explained, the op-ed also pushed for legislative and regulatory reforms that the ACLU has long supported as part of our women's rights and gender justice work. Who fucking cares? Who cares? So the ACLU pushed a liar to try and implement change. Thank you, ACLU. You're the worst fucking organization on the planet. And everybody would be happy if you rode off into the sunset and got hit by a goddamn nuke. Fuck you, ACLU. Go away. You were useful before. You are useless now. You don't care about rights. You don't care about civil liberty. You don't care about anything but leftist, Marxist agenda. And it's obvious. Get the fuck out. Go away. Leave society politely and get fucked. As well as to galvanize support for changes in the treatment of women who came forward to speak out against abuse. Why? Why? Heard advocated that readers help elect politicians who would assist in fighting abuse and pave the way for better investigations by providing proper follow-through of complaints and assurances of no retaliation. Better investigations would have gotten Amber Heard thrown into jail. In the op-ed, Ms. Heard explained that because she had spoken out against domestic abuse, she had been ostracized and lost employment as an actress. But this is a lie. Her biggest gigs came after she spoke out against abuse. Aquaman, Aquaman 2, those things happened after. It's a lie. As the Washington Post later wrote, the op-ed, quote, urged readers to support women who come forward with allegations of abuse by taking them seriously and electing politicians who will fight for changes to laws and rules and social norms. None of that has anything to do with the fact that she lied about Johnny Depp in the op-ed. All of the rest of the op-ed can be about flowers and rainbows and other stuff. But in the op-ed, she excoriated Johnny Depp. And it was a lie. It was shown to be a lie. That's the big problem that she's got. Citing Sonia Rayo, a timeline of Johnny Depp and Amber Heard's ongoing legal battle. Oh, great. Quoting the Heard op-ed. The op-ed never mentioned Heard's former husband, Johnny Depp, by name or by reference. That's not true, such as former spouse. Only by reference to the specific comments from 2 years prior that she stood up against domestic abuse when she filed for divorce against Johnny Depp and made a very public display of going to the court and getting an order for protection against him. Only those things, but she didn't technically say my former spouse, nor ever stated that Heard had been subjected to any particular type of abuse. Well, except for the headline did, but it doesn't matter. Any abuse is defamation per se. Instead, other than the contested passages, the op-ed merely explained that she had been exposed to abuse at a young age. Well, again, that's a pretty important caveat, isn't it? Other than the defamation, she didn't defame him. Thanks for the help, you idiots. Like, the people reading this are not stupid. The people reading this document, the judges and the clerks, are not stupid. In fact, they're typically pretty fucking smart. Other than the contested passages, the op-ed merely explained she had been exposed to abuse at a young age and that, like many women, she had been harassed and sexually assaulted by the time she was of college age. She wasn't sued over these things. Ms. Heard did not meet Johnny Depp until long after she was college age. So this reference cannot be to him. She wasn't sued over that reference. No one said she was. The introduction of the op-ed listed Ms. Heard as an actress and ambassador on women's rights at the ACLU. Who cares? The op-ed itself contains 2 sentences written by Ms. Heard that Mr. Depp claimed were defamatory by implication. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. Yes, 2 years ago. 2 years ago was obviously calling back to the specific time when you went and got a protective order against Johnny Depp very publicly. And Johnny Depp's team effectively showed by talking to TMZ and by calling a TMZ guy to the stand that you engineered the publicity around it. It was your choice to do so. Quote, I had the rare vantage of seeing in real time how institutions protect men accused of abuse. This is clearly referencing Johnny Depp. That's the only man you accused of abuse and institutions protected, even though they dropped him from fucking everything. They dropped him from everything, but they protected him, right? Neither mentions Mr. Depp nor specifies any type of abuse, mental, psychological, verbal, physical, emotional, or sexual type of abuse, but they both specifically call out abuse. They both specifically say abuse. Wow, they didn't say what type, though. The statements on their face do not assert that Ms. Heard was subjected to any abuse by Mr. Depp. Mr. Depp also asserted yet another passage was defamatory, but that allegation was dismissed. Trial court held that the statement is too opinion-laden and representative of defendant's own perspective for it to be actionable, and it notably lacks any implicit reference to the alleged meaning that Mr. Depp abused Ms. Heard. The court simply cannot find that this statement has a defamatory charge without extending the meaning of the words far beyond their ordinary and common acceptance. As this brief argues, this holding should have been applied to all of the op-ed's contested statements. Well, that's lovely, but it wasn't. The rest of the op-ed addressed the repercussions experienced by women who speak up regarding abuse. The op-ed took a broad view, referring to the Me Too movement and the history in Hollywood of facilitating abuse and punishing women who objected to it. Why don't you speak out about kids in Hollywood, you fucking liar? You're sitting here worried about adult women who make choices and regret them after they make millions of dollars. You're sitting here talking about adult women who are pressured to go into a hotel room. And by the way, there's millions of dollar contracts, lots of pressure. I'm going to agree with you. I think it's shitty to do. But my God, why don't you talk about the children who are routinely fucking abused by all of you monsters in Hollywood? All of them. You don't talk about that. You're not advocating about that. You're not writing an op-ed about that. The children of Hollywood are a bigger tragedy and travesty than anything facing any man or woman in Hollywood at all. And it's embarrassing that we as a society let that shit go all over the place. And that the real victims like Amber Heard are out here fucking whining that no, listen to this. Amber Heard isn't whining that she got sexually abused to get roles in Hollywood. She's whining that Hollywood closed ranks when she out of nowhere accuses Johnny Depp of abuse. And they didn't even close ranks. They did everything she wanted. They fired him from everything. And she's mad about that. Fuck her. Fuck these people. You notice what she didn't do? She didn't accuse anybody in Hollywood of abusing her or facilitating abuse for her to get her role. No. She didn't talk about anybody exploiting her looks, her sexuality to get where she was. At least the Me Too movement did that. At least they alleged that Harvey Weinstein was being a fucking creep to give women roles and to try and get his dick wet at the same time. At least the Me Too movement did that. What did Amber do? Nothing. Maybe that's what she's mad about. Nobody gave me some deformed, weird Harvey Weinstein penis to grab onto to elevate my career. It opined that we are in a transformative political moment in which women's rage and determination to end sexual violence are turning into a political force. Yeah, that died with COVID. I hope you realize, Amber. It's long gone now. Ms. Heard's general description of her own experience was limited to a few introductory sentences at the very beginning of the op-ed that were not associated with Mr. Depp. Except there were 3 sentences that were, the 2 mentioned plus the headline. Other negative publications about Mr. Depp. Other negative publications don't matter. While the Washington Post op-ed did not mention Johnny Depp, numerous other publications reported in great detail about his drug and alcohol abuse of Ms. Heard and others, and his failure to honor obligations to show up on sets in a timely manner, resulting in financial losses to studios. Let's get this very fucking clear. Someone like Johnny Depp being late to set is a bother to no one other than the crew, who are disposable. And I'm very fucking sorry to say that. If you are a crew person in Hollywood, it's not that you're not valuable. It's that you're not anywhere fucking near as valuable as the front-facing person of a movie. It's not even close. Best grip number 3 can't possibly compete with Johnny Depp in importance on Pirates of the Caribbean. It's a joke. So yeah, guess what, guys? The CEO gets to go play golf and bang hookers on company time. The mailroom guy doesn't, unless you work for GameStop. It's not fair, but it is real. And everybody who tries to pretend that it's not drives me fucking nuts. Drives me fucking crazy. These articles caused Mr. Depp's poor reputation among various studios and others in the movie industry years before the Heard op-ed was published. Johnny Depp did not have a poor reputation in the industry. Johnny Depp had a reputation for being something that studios and production crews needed to manage. It's not a poor reputation. That's a cost of doing business with Johnny Depp. And it's factored into the fucking contract. They know what they're getting with Johnny Depp, and they're still signing him for hundreds of millions of dollars. You go, okay, well, we're going to have to deal with a guy who's probably late, sometimes on drugs, a lot of times drunk, and we're still willing to pay him $100 million. Why? Oh, because he puts asses in the fucking chairs. Ms. Heard was prohibited from entering these into evidence based on an erroneous hearsay objection filed by the trial court. That's not an erroneous hearsay objection. That's a proper hearsay objection. What about those publications is not hearsay? Get the author of each article on the stand. Why don't you have that? Why don't you have the author of the article come on, say, yeah, I wrote this article because holy shit, this guy's a monster. Had these articles been admitted into evidence, the jury would have learned about other reporting that would have affected Mr. Depp's reputation. Bullet points. There were reliable predictions that Depp would not be in any more Pirates of the Caribbean movies almost 2 months before the op-ed was published. That wasn't a reliable prediction. That prediction was proved reliable by the Amber Heard statements. Depp's business managers filed... See, this is the thing. Even if Disney were considering not doing another Johnny Depp movie, without actual confirmation by Disney that they weren't going to do another Johnny Depp movie, and all they had to do, any Disney exec had to walk in and say, yeah, we were done after 5. Went on a little too long, was kind of tired. That's all they had to do. They didn't do that. Why not? Because they would have done a Pirate 6. But until that happens, they're still contemplating it. And therefore, the defamation article comes out and they go, okay, yeah, now we sever ties. Let's say that was the last straw that broke the camel's back. Guess what? That straw did the damage. The load before it didn't. Depp's business managers filed pleadings in a lawsuit against him, asserting they knew Depp had engaged in violence against Ms. Heard. Depp was described as extremely volatile and sometimes had gotten physical with Ms. Heard. Yeah, the people being sued, by the way, people being sued for stealing and squandering $600 million from Johnny Depp. Yeah, they were just taking his money. They're just stealing his money because he had gotten physical with Miss Heard. That was the noble and righteous thing to do, right? Depp drank heavily and was constantly late to the set during the filming of Pirates of the Caribbean 5. So, actors have been late and drunk for all time. Depp went on 72-hour drug binges, was only intermittently lucid, spent $30,000 per month on wine. Amber's wine! Amber's wine! That came out at trial. This isn't a good fact for you. The wine thing came out at trial, and it was Amber's wine. Uncontested, by the way, that it was hers. Mr. Depp contested this allegation, claiming he spent far more than $30,000 per month on wine. What a fucking champion. What a champion. Oh no, love, it was much more than $30,000 on wine. It was more like 50 to 100. Fucking hell. What a homie. Many of Depp's movies were bombing at the box office. Which ones? Which Depp movie was bombing at the box office? I'm kind of... Oh, it's defense exhibits. Who knows? Depp physically assaulted the location manager of his film, City of Lies, and was sued by the manager. All of the... By the way, this is a proper exclusion. All of this is properly excluded. But, okay. But I'm curious... I really am curious what movie bombed. Depp joked about assassinating President Donald Trump and was rebuked by the White House and others, requiring an apology from Depp. This is not at all relevant to this trial in any fucking way. In fact, let's say the quiet part out loud. This is better for him in Hollywood than anything else. This helps him. They hate Trump. Depp was going broke and selling many of his assets because of grossly excessive spending related to his drug, alcohol use, and extreme eccentricities. This is actually not true. It was literally the corruption of his business managers. That came through at trial. This is fucking insane. But this is the reason. By the way, Johnny Depp spending let's say he spends $50,000 a month on wine. So what? You make $100 million a year, $50,000 a month. Let's see what that's $500,000. What? 0.6 million per year. That's less than 0.1%. Like, so what? It's unreal amounts of money that these people make. It's unfathomable to the average person how much money that is. And we're like, well, you're spending 50 grand a month on wine. So it's a lifestyle that most people can't understand. Yeah. Ola Kyle says that would be the equivalent of $50 a month for someone making $100K a year. It's unrealistic. Like, it's unreasonable to sit here and be like, wow, but they're trying to shock with numbers, but those numbers aren't shocking when you're talking about $100 million a year. None of these articles were sought to be introduced for the truth of the matter asserted. Yes, they were, but rather to demonstrate that other publications contain more damaging allegations against Mr. Depp. The more damaging allegations are the truth you're trying to assert, you dumb fucks. Like, this is the law around hearsay. So long as it's not presented to assert that, or for the truth of the matter asserted in the article, you can introduce it if it's probative and not unreasonably prejudicial. But okay, all of these are for the truth of the matter asserted. Numerous articles mention Johnny Depp's alleged abuse of Miss Heard. Oh, so what truth are you asserting with this article other than that he abused Miss Heard? What truth are you asserting with excessive spending was leading to the depreciation of his assets, not Mrs. Heard's defamation? What truth was it that you're trying to get to? Well, someone else posted something negative about Depp. Okay, those things are irrelevant to the question at hand. So what truth are you trying to assert? None of these articles, but rather to demonstrate that other publications contain more damaging allegations about Mr. Depp and were more likely the basis of any difficulties experienced by him obtaining movie roles, except you couldn't find anyone to say this. You couldn't find a single person, not a single producer or director or executive producer or studio exec would say that anything was the particular basis. They were all very circumspect in their answers, of course, but none of them would say that these articles did it. Yet the trial court did not permit the jurors to view these articles. Good. That's the right move by the trial court, not the wrong move. Also, going against a trial judge at a district court level at the appeals court for evidentiary decisions is really fucking hard. It's really difficult. They're fighting an uphill battle here. All the allegations Mr. Depp now contends were implicit within the op-ed provisions were not only public knowledge, but they had been circulated ad nauseum long prior to the publication of the op-ed. But see, here's the thing I talked about during the Vic trial, or during the Vic stuff. And I know that the Vic case didn't go as many of us would have hoped it would go, me included, but that's a whole separate story that has to do with a long question about lawyering and other stuff and weird shit involved with that. All of these things are very fact and individual specific, but this is what we talked about. The fact that other stuff was said before and nothing happened actually lends more credibility to the more credible source disclosing information and then something happening. So all of this stuff was done before, and Johnny Depp still got movie roles. Amber Heard comes out as someone close to the issue, as the direct purported victim, and makes the accusation. And suddenly we have a whole different ball game now. News articles saying Johnny Depp did something are one thing. Johnny Depp's wife saying this motherfucker abused me is a whole different ball game. And the fact that we're ever having to like reasonably try and discern the distinction between some faceless journalist looking for clips and the actual purported victim coming out and saying something is ludicrous. And they do it every single time. Well, someone else said something. Yeah, but someone else said something and nothing happened. and nothing happened. And nothing happened is always the answer. When you go back to any of these defamation cases and look, well, another article said this and nothing happened, right? Well, yeah, but something was going to happen. Says fucking who? Says who? Says you right now in the most self-serving way possible? Yeah, okay. But says fucking who? Says nobody, of course. Depp's on. Oh wait, here. C. Cardillo versus Doubleday Company, Doubleday and Company Incorporated. Virginia appellate courts have not yet considered this doctrine. Oh well, that's a loser of a fucking argument. Good job. Depp's unsuccessful British lawsuit against the Sun. This is completely irrelevant to this case. One of the most damning of the articles published before Ms. Heard wrote this op-ed was written by Dan Wootton in the Sun, a British newspaper. Not really a newspaper, a British rag. How can J.K. Rowling be genuinely happy casting Johnny Depp in the new Fantastic Beasts films after assault claim? Mr. Wooten expressly stated that overwhelming evidence was filed in the California proceedings against Johnny Depp by Heard to show Johnny Depp engaged in domestic violence against his wife, Amber Heard. Wooten explicitly encouraged J.K. Rowling, the author of Harry Potter book series, and Warner Brothers, the studio making the Harry Potter movies, to fire Depp from his role playing one of the key characters in Fantastic Beasts. This is all true. This is all done in firm reliance on Amber Heard's statements, though. In response to this article, Mr. Depp, through his counsel in the current case, Brown Rudnick, filed a lawsuit before the High Court of England and Wales on June 1st, 2018, against Wooten and the publisher of the New York Sun News Group, claiming irreparable harm from the Sun article. The defendants filed a re-amended defense, pretty rad, that relied upon a truth defense, specifically that claimant Depp beat his wife Amber, causing her to suffer significant injury on occasion, leading her to fear for her life. Now, again, I've gone through this a million times. The Sun article is relying on statements by Amber Heard to make its claims. The judge in the Sun article, the judge's son is best friends with Dan Wooten or whatever. The wife hangs out with Dan Wooten's wife. Like, it's insane how connected this judge is to the UK Sun. And the judge should have been recused. Under American standards, probably would have been. Also, Amber Heard doesn't get to be cross-examined because it's England. You don't have a right to confront your accusers there, only in the US. It's insane. All of the shit that happened in the UK trial is a fucking disaster. The Sun argued that the claimant and Miss Heard began living together in or about 2012, married on 3rd of February 2015. They separated on or around 22nd May 2016. Throughout their relationship, the claimant was controlling and verbally and physically abusive towards Miss Heard, particularly when he was under the influence of alcohol or drugs. Okay, cute. After 16 days of hearings in the case, November 2nd, 2020, Mr. Justice Nicholl, sitting in the British High Court of Justice, Queen's Bench Division, issued his judgment, a 129-page, 585-paragraph decision, which found that the statements in the Sun that Depp beat his wife Amber Heard, causing her significant injury, and on occasion leading her into fear for her life, were substantially true. Substantially based on her statements that were relied upon in writing the article and relied upon in court, of course. In the judgment, the High Court noted that the burden of proof, the civil standard of proof, namely the balance of probabilities, was on the defendants to establish that the statements were true. High Court found that the great majority of the alleged assaults, 12 of 14. By the way, 12 of 14 is actually an embarrassing number. It's actually an embarrassing number. It should be 14 of 14. That they couldn't win with this low standard, that they couldn't win on all 14, should be sus. And this is the difference between the American and the British version. In the American version, if you have one claim that is not substantiated, the jury goes, wait, what else are you lying about? What the fuck else would you be lying about? The High Court found that the great majority of the alleged assaults have been proved to the civil standard. As a result, the High Court dismissed the claim brought by Depp against the defendants. Look, I'm just going to say it. This is section 3. We're in section 3. The second section was weak, other publications that were excluded by the trial court. And the third section now is, well, there was a court in another fucking continent with a different legal system where he won against a different defendant. Like, that's the argument. When we're here on section 3, your case is shit. It's absolute trash. And they know it. On March 25, 2021, the Court of Appeals refused Mr. Depp's application for permission to appeal the judgment. And if that doesn't say enough, if this case, if Johnny Depp versus Amber Heard here were heard in the UK, she wouldn't be allowed to file an appeal either. That is a firm fucking abridgment of rights that we are gladly away from. More than 2 years after this article, Mr. Depp resigned from this role after losing his lawsuit in November 2020. What role? Johnny Depp's dismissal from the Fantastic Beasts franchise marks a major career repercussion for the embattled actor. The trial court's rulings on the extent to which Miss Heard's counsel could mention or introduce evidence about the Sun article, lawsuit, and judgment was an arbitrary moving target. Nope. It should not be mentioned. It's entirely prejudicial. There's nothing probative about that. Although Mr. Depp filed a motion in limine seeking to exclude evidence about the UK judgment, only blank, which was granted in part, the trial court barred Miss Heard's counsel from any mention of the Sun article, lawsuit, judgment, or anything in the UK. Good. None of it in the UK matters. Moreover, the court never permitted the Sun article itself to be introduced into evidence. It shouldn't be, despite its clear relevance to the issue of causation regarding any alleged damage to Mr. Depp's reputation. Nope. She actually properly gave an instruction limiting the scope of damages to after the UK article's conclusion. So this is wrong. Later in the trial, the court allowed some testimony about the Sun article, but still refused to allow the article into evidence. This is particularly harmful given the fact that Mr. Depp lost his significant role in Harry Potter movies that the UK judgment was released. Except the Harry Potter movies were not actually, the Fantastic Beast movies were not actually part of this shit. And not part of the damages calculation. They made that very fucking clear. Press about Mr. Depp at the time of filing the Sun case by Depp in June 2018, during the hearings and trial in July 2020, and after the judgment was released in November 2nd. Depp versus Heard trial. Okay, back to this. Back to the actual trial at hand. To say that the Depp versus Heard trial in Fairfax County Circuit Court and its surroundings was a circus is a gross understatement. Really, is it? As the unofficial video record has shown, the outside entrance drop-off gauntlet through which both parties entered the courthouse and through which Depp was championed and Heard was vilified in the conduct of the courtroom audience and some of the participants created an atmosphere more appropriate for a trivialized wrestling match than a court's trial impacting people's lives. This is bullshit. The gauntlet they had to go through was removed from the courthouse by a couple blocks, which is about, they have to balance reasonableness of the restrictions under the First Amendment. People get to express disdain for a particular person in a lawsuit. You get to do that. That is your fucking freedom. You have a right to say, Amber Heard's a fucking or Johnny Depp's an abusive piece of shit. You get to say that right outside the courtroom. You don't get to say it in the courtroom. And yet we're supposed to pretend like none of that can happen. That happens all the time and should. So here's number 10. As PBS noted, while the jury deliberated, the streets outside the Fairfax, Virginia courtroom became a pro-Depp carnival. Think about, again, this is about legal strategy and framing. This isn't about facts anymore. This is narrative, and this is often overlooked. But look, so my independent study as a senior in law school was this. One of my law professors was very nice and who probably disagrees with me vehemently, politically. Vehemently. She was writing a law school article and asked me to do some research for her and write up a summary of the research. All right. And this is about a very, very important topic in law school pedagogy. Pedagogy is the study of teaching. All right. And the method of teaching a thing. Her contention was that law school does not focus properly on teaching narrative as part of the required curriculum. Storytelling. How do you engage the audience? The audience is either the judge or the jury. Tell a compelling story. This is fucking critical. I can't express this enough. All your arguments are for naught if they fall on deaf ears because those deaf ears are bored. So tell the story. Now, here they're trying to tell the story, right? Of how unfair this trial was to Amber Heard. And the line of the story right now to convince these judges that it's unfair is this. After the trial, during jury deliberations, after all these people engaged in the trial have watched the most public trial since O.J. Simpson, have watched and engaged the content, after all of that, after all the parties have submitted their evidence, what we have in these streets is a pro Johnny Depp carnival. Think about that. Think about how stupid of an avenue of approach it is to say that. So after the parties did all their testimony, submitted all their evidence, made their opening and closing statements, after all of that, the crowd is pro Johnny Depp. And we want this court to come in and overturn what not only the jury has decided, but also the chat, right? Like the audience, the people who watched, the people who care. They're all there and they're like, fuck. Now, a much better argument would be to go with the pre-trial, everybody being pro Johnny Depp pre-trial would be the smarter article to cite, right? Trial hasn't even begun. No evidence is submitted, and this crowd is uniformly pro Johnny Depp, showing the power of a male celebrity to influence crowds without saying a single word, and the difficulty for a woman to stand up in a male-dominated environment. Bam! That's a fucking headline, you. Why can't you figure this out? It's so goddamn easy. I do it in my sleep. I do it while drunk on it. This is how you sell the fucking appeals court that Johnny Depp was winning before he stepped in the room. That's not fair. That's how you go against the court process, but you can't do it, can you? Because you're too fucking dumb. So you wait until after all of the evidence has been submitted and say, well, after all the evidence, everybody's in favor of Johnny Depp. Oh, Jesus Christ, what a calamity. Narrative. Tell the fucking story. Tell the fucking story. Tell the story you want to tell to the court. Tell the story. Make the other side defend against the story, because then they're on the defense. Then they're having to post, well, no, this is the real article. We wanted you to pay attention. It never works. The first one wins all the time. It gets primacy in the brain. The first one you pick is that after everything, people side with Johnny Depp along with the jury. You know what would have been better? The jury sided with Johnny Depp, but everybody else sided with Amber Heard. Boom, there's an unreasonable jury. Can't do it. Everybody agreed with the jury's decision is a very reasonable jury argument. And Johnny Depp's team, when they responded to this, should be like, yes, actually, we know that those people outside celebrating, many of which were in the court every single day or multiple days. And when they couldn't be in court, they were watching online at here. Don't even mention me. Mention Law and Crime, the biggest channel covering all this. They're watching at Law and Crime. They're watching these objective news sources. They're watching summaries. They're consuming all of the content that could ever possibly be found. And I'm sure there's articles about this. They're consuming everything about Johnny Depp. They know more than the jury does, and they agree with the jury. That is the most reasonable fucking jury we can possibly imagine. That would be in my response to this, of course. And yet these people just lobbing softballs over Johnny Depp's team. Home runs all fucking day in this brief. It's legitimately insane. This is a stupid brief. It's actually dumb. And the conduct of the courtroom audience and some of the participants created an atmosphere more appropriate for a trivialized wrestling match than a court trial impacting people's lives. Social media lambasted, misheard, and viciously attacked anyone who expressed opposition to Depp. Who cares? Again, so social media is on the side of the jury. People outside the courtroom are on the side of the jury. Sounds like the jury's reasonable. Your goal in this brief is to say that the jury verdict is unreasonable. Not only that it's unreasonable, that no reasonable jury could have come to this conclusion. That's the standard you have to overcome. No reasonable jury with the evidence submitted could have come to this answer. None. That's what you have to fight. That's what you're fighting. And they say, so the jury came to this conclusion. The crowd at the court came to this conclusion. And the crowd online who watched this came to the same conclusion. How is the jury unreasonable now? How is the jury aberrant in this situation? How are they different in this situation? How is the jury not following the same narrative that every other American is following? Tell me. Tell me more about it. You have one job. Tell the fucking story, and they can't do it. They can't tell the story. They don't know how. And that's a law school failure, I guess. I could have written a better amicus brief for Amber Heard than this, because I just would have told the story in favor of Amber Heard rather than in favor of Johnny Depp. Here's an article: Targeted Trolling and Trend Manipulation, How Organized Attacks on Amber Heard and Other Women Thrive on Twitter, report by Bot Sentinel. Boozy, you fucking fetal alcohol syndrome induced crack baby. You goddamn idiot. You did it. You made the dumbest fucking report on the planet. They quoted Boozy. They quoted a guy who can barely buy groceries. Embarrassing. Stay away from it. Stay away from people like Bot Sentinel. Let me say it. C. Boozy is an uneducated working out of his kitchen, which is tiny, with no experience, no qualification, no established credibility, because I'm not a qualification snob, but he doesn't have established credibility either. He wrote some bullshit code to troll through Twitter replies and determine who are bots. And the way he determines it is length of time and number of followers, like a fucking moron. As if there are tons of people on Twitter who don't spend 10 years trying to get 10 followers and never get them. Like that those accounts are somehow invalid. No. See, Boozy, you are objectively fucking dumb. You're bankrupt. You're a terrible grifter because you're still fucking poor. If you're so smart, why aren't you rich? And you aren't, despite having a hand job to the mouth from the Twitter gods of old, you still are poor, broadcasting from like writing your bullshit from like a 1-bedroom apartment's kitchen that doesn't even have a microwave or a toaster. My God, I'm going to send you an air fryer. And the funny thing is, you won't be able to put it in your kitchen because there's no fucking room. You're that fucking broke. And yet, here you are, cited in an Amber Heard thing as if you matter. It's cute. But guess what? When they lose, your credibility will take yet another hit because you are weak. You're weak-willed and your mind is small. Sue me, Boozy. I dare you. I'll wreck your ass harder than your bow. By the way, Nate's going to spread you open and make you look like a dumb bitch that you are. The lack of decorum was further exacerbated by social media postings which belittled Heard and heralded Depp. There is no decorum on social media. There is no decorum on social media. You know how I know this? I'm on social media. If there was decorum, I'd be off of all of it. Social media is immune to decorum. Well, they were on Twitter and they didn't abide by the rules of court. Oh, fuck off. Like, come on, fuck off. What are we talking about here? Attorneys for Depp were shown making inappropriate gestures and harassing witnesses when they were on the stand. Nope. Here we go. The video of the trial showed Depp's counsel making inappropriate gestures toward Miss Heard. Watch live as Amber Heard's second day of testimony at Johnny Depp defamation trial continues, as well as engaging in inappropriate celebration during certain testimony by Miss Heard. Oh, yeah, they were happy that Miss Heard said something stupid. These are not good narrative points. On May 5th, Mr. Depp's lead lawyer, Mr. Chu, pumped his fist in front of the jury, appearing to celebrate the mention, which opened the door for Miss Moss to be called to testify about her relationship with Mr. Depp. Imagine honestly putting in a brief. Well, they knew they had won so thoroughly that he went, yeah, in front of the jury. Who fucking cares? Like, who? We get to bring Kate Moss on the stand to absolutely wreck this lying bitch. We get to do it. It'll be perfect. Oh, God, I can't wait. We get to call Kate fucking Moss. Who doesn't like Kate Moss? Oh, supermodel Kate Moss. Oh, she's been around for, oh, she's still kind of pretty. Bam, fist bump. Oh, she's going to say Johnny Depp never shoved her down the stairs and that Amber Heard made up the entire narrative in her own mind and it didn't exist outside of Amber Heard's mind until she mentioned it. Boom. Yes, I would fist bump too. I'd be doing the meat spin helicopter. Like, what are you talking about? So happy. Why would they mention Kate Moss? Why is Amber Heard so stupid? Why was she so unprepared? These are questions we need to ask. And yet, they're blaming Johnny Depp for all of it. While being praised by the mob, Depp attorney gets rock star treatment leaving court. All these elements, which are predictable results of defamation suits improperly filed and involving public figures, you just literally made this up, chill speakers who would be protected by the First Amendment. Nope, you're not protected by the First Amendment to defame someone. It's not real. I know this is hard. And look, as a free speech absolutist, as a First Amendment absolutist, this is a difficult position for me to take because I love free speech. I love it beyond everything. But this is not protected by the Constitution. It never fucking has been. Defamation of reputation. You know how they used to solve this, by the way? You know they used to solve defamation before it went to court? You got fucking shot. You got fucking shot. You were killed or severely injured. That's how defamation was solved before court. Free speech existed because duels existed. We stopped dueling as a practice. You want free speech to exist? Bring back fucking duels, motherfucker. I dare you. I dare you to try. Because guess what? If the courts don't do it, people will. That's how it goes. If people lose faith in the courts, you get violence. The courts are there to mitigate street violence. And yet, got a bunch of people like, we don't want the courts to intervene here. Sorry. Reputation is everything for a lot of people these days. We've created an economy that requires or that relies upon reputation and credibility. I'm in there. If people don't find me credible or reputable, they don't watch. Predictable results of defamation suits improperly filed and involving public figures. Chill speakers who should be protected by the First Amendment. There is no First Amendment protection on defamation. It is difficult to overstate the amount of historical interest the case attracted and its long-term impact. Broadcast of YouTube's 6 segments amassed a total of 83.9 million hours watched. with a 3.9 million peak viewers during the announcement of the verdict. So they're citing Law and Crime on that one. Baden Zavura, Johnny Depp and the Amber Heard trial. How many viewers gathered on YouTube and how it was discussed on Twitch. The opening argument of Mr. Depp's counsel, the evidence presented by Depp and Depp's closing argument would lead to a reasonable jury to believe that the defamation being sued on by Mr. Depp was not the op-ed itself, but rather the allegations of abuse by Ms. Heard in 2016 and her California court filings and subsequent press coverage of those filings at the time. Okay, but here's the deal. If that's true, then we have to consider defamation by implication is a real thing in Virginia, and you're still fucked because that's still law. Until the legislature changes the law on defamation by implication, you have just implicated all of these other statements involved in the Johnny Depp case. I don't think that's actually true, but that's what you did. So you still aren't making a winning argument. And nowhere in this document, in the first 25 fucking pages, have you seen anything close to a sensible, cogent argument in favor of Amber Heard? You've seen a bunch of railing against the law, but railing against the law doesn't mean the law is invalid. As Benjamin Chu, Depp's attorney, stated in his opening, the evidence will show that Ms. Heard's false allegations, in brackets, in 2016, they just added that shit, had a significant impact on Mr. Depp's family's ability to work. Wait, you don't get to just add in 2016 and change the meaning of his statement. This is a flat out fucking lie. Can you imagine doing this? It's literally a lie to the court. They just added brackets and added context that didn't exist in the opening statement. They changed the statement fucking entirely. Depp's counsel later argued what is at stake in this trial is a man's life, the life that he lost when he was accused of a heinous crime. Correct? Only later did Mr. Depp's counsel correctly argue that this case... Correctly argue! No. The word the other counsel correctly argued should never appear in your opposition brief. What the fuck? What the fuck are you doing it? What are you doing? Correctly argue that this case is about what Ms. Heard said in her op-ed, but then went on to distort what Ms. Heard said, even by implication. Nope. Depp's, again, don't put it in there. Don't give the idea that they correctly argued. Everything should be incorrect. Everything should be negative. Everything should be improper. You're fighting for your clients. Well, in this case, it's an amicus, but you're fighting for the principle, your own life. That's when you're an amicus, you're not fighting for someone else's life. You're fighting for yours. Depp's counsel argued that Ms. Heard painted a picture of herself as a heroic, innocent survivor of the abuse by Mr. Depp, a beaten woman who finally stood up to her tormentor. The evidence will show that Ms. Heard portrayed Mr. Depp as a representative of abusers everywhere, the agent of her suffering, the villain in her heroic journey. That was a good argument. That was a really fucking good argument, by the way. Evidence in the case was presented over 23 trial days. Interestingly, Depp did not introduce into evidence a copy of the op-ed that was the basis of the lawsuit until April 20th, 2022, the seventh day of evidence. Who cares when he introduced it? It was introduced. The print version of the op-ed was entered into evidence for the first time by Ms. Heard's counsel during his cross-examination on April 20th. After Depp's direct examination, the questioning of 10 other witnesses had been completed. Depp's counsel did not introduce the online version of the op-ed until the 9th day of trial during his redirect testimony. And his counsel mentioned it only in passing during their opening statement. During trial, Mr. Depp asserted that when Ms. Heard made her abuse accusations against him in May 2016, these accusations had an immediate impact on his career, saying that when she made those accusations, he lost nothing less than everything. His counsel repeatedly argued that Mr. Depp's claims were focused on the allegations that Ms. Heard made in 2016, twice referring 6 years to the day of the argument. Yes, this is defamation by implication. Mr. Depp asserted that when Ms. Heard made the abuse accusations against him in May 2016, these accusations had an immediate impact on his career, saying that when she made those accusations, he lost nothing less than everything. His counsel repeatedly argued that Mr. Depp's claims were focused on the allegations that Ms. Heard made in 2016, twice referencing 6 years to the day of the argument, 6 years ago, blah, blah. So what they're gonna do, I haven't read this yet, but I'm gonna guess is that they're gonna say, well, the judge limited the damages to 2018 versus 2020, which the judge did. But here's the critical important part. The judge limited the damages to 2018 versus 2020. The judge did not limit the cause of the damages to 2018 versus 2020. The judge, Ascarati, knowing that this is a case about implication and reference to a prior statement, did not limit the creation of the damages, only the amount of damages. And this is a critical misstep that I know this amicus brief is going to take. It's an embarrassment that they're going to try this, because here's the thing. You can limit the scope of damages to these dates, but still have the source of the damages be prior to those dates. You're going to conflate those things. It's going to fall flat on the appeals court. It's going to fall flat on everything. Mr. Depp's counsel began the closing argument by asserting that on May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles, California to get a no-notice ex parte restraining order against Mr. Depp, and in doing so, ruined his life by falsely telling the world she was a survivor of domestic abuse at the hands of. First, in 2016, Ms. Heard did become a public figure representing domestic abuse, who eventually spoke on behalf of the ACLU about abuse, and eventually speaking on behalf of the ACLU about sexual abuse and domestic violence. Cute, except you're losing the fucking argument, because that's not the critical aspect of this. The critical aspect of this is, did she defame Johnny Depp? Not this other part. For this advocacy, she was subjected to severely adverse responses. Quoting Abigail Rowe, the backlash against Amber Heard follows a sad, predictable pattern. From complex.com. Second, Ms. Heard has seen that institutions provide protection to men who have been accused of abuse. Third, as an individual and later an ACLU representative, she spoke about Amber Heard had literal institutional protection from the ACLU. And we're supposed to pretend she didn't. We're supposed to pretend that only Johnny Depp got institutional protection. The ACLU is one of the most powerful legal movements in modern society. There was no mention of Ms. Heard's marriage to Mr. Depp or any mention of him during the op-ed. Nonetheless, Mr. Depp alleges that each of these statements were defamatory by implication. They obviously were. They were taken that way. It was shown in the USA Today article. Depp asserts that these three statements are of and concerning Mr. Depp, and as he is Ms. Heard's former husband, and she publicly and falsely accused him of domestic abuse in May 2016. Moreover, Ms. Heard intended to refer to Mr. Depp in these statements, and those who know Mr. Depp or who read the sexual violence op-ed understood these statements to be about Mr. Depp. Great. Depp further claimed that these statements, which imply that Ms. Heard was the victim of domestic violence at the hands of Mr. Depp, are false. Yes. There was no temporal relationship between the allegations of abuse by Ms. Heard with the resulting publicity of the op-ed article. The trial court allowed these claims to move forward despite the fact that the information that Mr. Depp used to establish the implications were made when Ms. Heard obtained a temporary restraining order over 2 years prior to the op-ed being published. Yes, they hearken back to the op-ed. Moreover, there was no evidence presented that the Washington Post, the forum for the op-ed, had ever published any of the information relied upon to flesh out the alleged defamation. Doesn't matter, because the Washington Post wasn't sued. Only Amber Heard was sued. There was no evidence that the Washington Post had previously published articles about these allegations, which were protected in 2016 and beyond any statutes or limitations anytime in near proximity to the op-ed. This is irrelevant. They weren't sued. There could be no implication that the readers of the op-ed would have had a reasonable basis to assume these facially true and unrelated comments were about Mr. Depp, except for the USA Today article, which specifically laid out they were obviously about Mr. Depp. Mr. Depp stretches the meaning of the words used by Ms. Heard beyond their normal meaning and reasonable construction. The op-ed, see Tara Terolareus versus Pirro, statement that Mobile Oil president set up his son in business could not be extended to interpret that president had set up entire business relationship to benefit son. That's way different. Republication of the headline written by a Washington Post staffer cannot be the basis of liability. This is probably their strongest claim, and it's not a good one. Although the Supreme Court of Virginia has not formally addressed the issue, Amici believes that the Fourth Circuit is correct, that Virginia would follow the great majority of states that now follow the single publication rule. See Morrissey versus William Morrow Company, citation omitted. Under the single publication rule, a statement on a website is not republished unless the statement itself is substantively altered or added to, or the website is directed to a new audience. This actually happened. The Washington Post published their article. Amber Heard retweeted it with a comment which directed her audience to the Washington Post. Now, I know her audience are all astute readers of WAPO or whatever, but there's probably one fucking follows Amber Heard that does not follow the Washington Post. And if they go to look to the Washington Post for the first time in like maybe 5 years, and they're like, well, I guess because Amber told me to look, I'll look. That does change the publication. That's Iramo versus Rolling Stone. A mere hyperlink without more cannot constitute republication, but there was more. She typed a statement. It wasn't a hyperlink. It was a quote tweet on Twitter with a news statement attached. It is uncontested that a Washington Post staffer wrote the headline, Amber Heard, I spoke up against sexual violence and face the culture's wrath. That has to change. Or that Ms. Heard did not participate in the creation of the headline. Cool. It's uncontroverted that Ms. Heard sent out a tweet, a message on her social platform, Twitter, forwarding an online copy of her article to her followers on that platform without adopting or addressing the heading. Wrong. By tweeting it, she did actually just adopt the heading. She could have copy and pasted in a tweet thread, which would have gotten more engagement, by the way, a multi-phase or a multi-part statement on the issue. It would have been like 40, 50 fucking posts. One question mark, right? And then you get to 53/end. And you write the end of the article. She could have done that. She didn't do that. She adopted the headline by retweeting that article specifically. Nonetheless, the jury in its verdict found not only that she was liable for the headline, but that the republication was with actual malice. Yes, of course it was. But in the present case, the facts are not sufficient to establish that Ms. Heard's lone tweet was a republication, for which she can be liable in defamation, as it did not alter the headline, did not add to the headline, nor did it discuss the headline in any manner. So she had the opportunity to correct the headline. By the way, I didn't write that he was a perpetrator of sexual violence, but Mr. Depp abused me in many ways. There you go. Done. You just changed the headline. Would have been better. If this tweet is considered republication under Virginia law, then numerous other links on social media platforms and to publications would create a liability for millions of Virginians. Good. Mr. Depp provided no causal connection between the op-ed and any alleged injury. We're way deep in the woods here. These are all the early arguments were the strong ones, and those were weak. I hope you understand that. For your fourth point on a appellate brief, this is like I'm throwing everything at this argument. This is all I have left. Damages are not normally awarded when they are uncertain, contingent, or speculative. That's not true. Citing a Barnes versus Graham, Virginia quarries, breach of fiduciary duty and statutory conspiracy to injure business. Thank you. That none of that actually happened here. Likewise, causation must be established in order to support a defamation verdict. Okay. Citing Bryant, Shannon versus Hampton Roads. A statement must contain the requisite defamatory sting to be actionable. Okay. Given that Mr. Depp was awarded $10 million in compensatory damages by the jury, Due process requires some basis for such an award. If large claims for defamation can be awarded in the absence of evidence of causation of harm, media organizations across the Commonwealth have good reason to shut down their editorial and news departments in fear of such an enormous potential verdict, despite the fact that no news publication was sued here. Mr. Depp's counsel presented a distorted view of whether the op-ed actually caused harm to Mr. Depp. There's no evidence that any Hollywood or other movie executive relied upon Mr. Heard's or Miss Heard's vague references to her being ostracized for becoming a public figure representing domestic abuse to deny Mr. Depp any role. I mean, except for the people who said, yeah, it could have been that. On the contrary, there were numerous prior publications demonstrating the risks and dangers of employing Mr. Depp, and none of those were acted upon, which is a key thing. This is not the argument you think it is. In fact, although Mr. Depp asserted that most of his damages from the op-ed were the result of Disney refusing to hire him for Pirates of the Caribbean 6, a movie that is yet to be made, Disney's corporate designee testified that Disney had found no copies of the op-ed or emails. Wrong. She testified that she had seen no copies of the op-ed or emails discussing the op-ed in his files. It's a misrepresentation of the evidence. Despite having copies and discussions of many other negative articles about Mr. Depp and a copy of the UK judgment in his files, there can be little doubt Mr. Depp's reputations and actions were well known long before the publication of the op-ed. Why couldn't you get them? Why couldn't you get them to just say, yeah, it wasn't the op-ed, it was anything else? Because they won't. But you can't do it. You couldn't do it. Over and over, you had the opportunity to do it, and you just fucking couldn't. It is also alarming that the verdict was allowed to stand. Allowed to stand, huh? Given an utter lack of causation evidence, showing that this one op-ed was the source of Depp's financial troubles, especially given Depp's previous unsuccessful defamations regarding statements from the English newspaper The Sun and another court. This is not, again, not the winning argument you think it is. Mr. Depp's counsel in that case claimed that the wife beater assertion in the Sun article was a reputation-destroying, career-ending allegation. Yes. How could anything said by innuendo by Ms. Heard in the December 18th op-ed have damaged Mr. Depp if his reputation had allegedly already been destroyed, his career ended when the Sun article was published? Because you further harmed him based on those things through implication. You did that. You called back to them specifically. It is understandable that the jury was misled in believing that there was such a connection between the changes in Mr. Depp's career trajectory and Ms. Heard's previous statements. How is it understandable? It shouldn't be understandable. How? If it's understandable, the jury is reasonable. I don't know. Again, like, give me a second to rant about this. Your entire argument must rely on the standard. The standard is that no reasonable jury could have come to this conclusion, period. None, not a single reasonable jury. Nobody could have done it. No reasonable observer could get to this conclusion. And yet you have statements that say it is understandable that means a reasonable jury could come to a conclusion that you disagree with. That isn't how you win. That is how you fucking lose, you goddamn dumb losers. No reasonable jury could conclude X. Not a reasonable jury could have concluded Y. No reasonable jury could have concluded X. That's the answer. If you say anything less in your appellate brief, you lose, you lose, you lose. Good day, sir. Go get fucked in a glory hole. Nobody is interested in your sad story. You must maintain that no reasonable jury can X. If a reasonable jury might have concluded otherwise, you've lost. You've lost. Might is ambiguous and you fucking lost. On the contrary, there were numerous prior publications demonstrating the risk and dangers of employing Mr. Depp. In fact, although Mr. Depp asserted that most of his damages from the op-ed were the result of Disney refusing to hire him for Pirates of the Caribbean 6, Disney corporate, blah, blah. There can be little doubt his reputations long before the publications of the op-ed. Also alarming, the verdict was allowed to stand given the utter lack of causation evidence showing that his one op-ed was the source of Depp's financial troubles, especially given Depp's previous unsuccessful defamation suit. Blah, 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 blah. How could anything said by innuendo by Miss Heard have damaged Mr. Depp if his reputation had already been destroyed? His career ended when the Sun article was published. It is understandable that this jury was misled into believing there was such a connection held between charges in Mr. Depp's career trajectory and Miss Heard's previous statements long before the publication of the op-ed, given that the jury was not permitted to see the evidence or other publications which were strongly critical of Mr. Depp, especially the Sun article and subsequent high court trial. For 6 weeks, jury was exposed only to the alleged statements by Miss Heard from April 16 through the op-ed's publication in November 2018, without the context of other critical publications regarding Mr. Depp. Trial court should have dismissed this action based upon comity. In addition to the First Amendment concerns regarding this verdict, there's reason for the amici to be concerned. The trial court gave short shrift to the UK High Court's decision, finding it was substantially true that Mr. Depp engaged in spousal abuse against Ms. Heard. This is a super losing argument that Mr. Depp engaged in spousal abuse against Ms. Heard, causing her to suffer significant injury and on occasion leading her to fear for her life. The UK court further found the abuse to have sexual dimensions and prodigious amounts of property damage caused during jealous sexual accusations and non-contact sexual violence against Ms. Heard, which created a probable balance for sexual assault. You won the case and you're talking about probable balance. You're talking about probable balance after winning. If you win a case and you're talking about probable balance, you've lost. But here's the reality. Comity says that one court should listen to another court. Great within the U.S. Shit outside of the U.S. The U.K., why would you listen to a U.K. court in U.S. law? Ever. Why? What purpose do they have? What credibility is built by the court by listening to a UCUC court for U.S. law? The UK court found further found the abuse to have sexual dimensions and pretty blah, 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 blah. The Fairfax trial court held that, quote, the libel laws of Virginia are starkly different than those of England. Yes. The Declaration of Independence and the First Amendment of the United States Constitution represent major departures from the English common law with respects to freedom of speech and freedom of the press. Yes. It's a good decision. Good lines. This is illogical, given that any First Amendment protections implicated by the alleged defamation in the op-ed would have protected Heard's speech. Nope, not Depp's interests. Wrong. How the Declaration of Independence affects the party's legal interests regarding defamation in this matter is a mystery to Amici. That's because Amici's fucking stupid. Of course, us saying, like, legitimately, do people not know that half of our divorce from England was not just taxes on the price of tea? It was the courts, baby. It was the courts. You didn't have representation. You didn't have rights. You didn't have protections. You didn't have the right to counsel. You didn't have fucking anything. The courts were supposed to protect us from the crown. We said, fuck right off to England because they don't have rights. And all you England cucks out there being like, we have free speech too. No, you have a rule that no parliament can be bound by a prior act of parliament, which means you don't have free speech. You have speech at the sufferance of parliament. We have in our constitution free speech, period. It's way different. It's way different. And the idea that you have free speech was firmly fucking demolished during COVID. Ours was tarnished. Yours was ass blasted like a gay on Halloween. Fuck off with your, we have freedom too. No, you don't. And you know you don't. You have pretend privileges granted you by each section of Congress or of your parliament. We have real rights, and they're not always upheld in the best way, but they're at least fucking written down. That's it. That's all we ask. Just write them the fuck down and maybe enforce them from time to time. We're way different than you. The considerations regarding comity and the UK judgment supported its application in the present case. No. Depp demanded that the UK action be tried first because of the favorable burden of proof in the UK. Yeah, but he was fighting a different party. It's a different party. He was fighting the Sun, not Amber Heard. They're factually different bases. They're legally different bases. In the current age, when a fact is published in one form, it is often picked up and republished in various other media. Yes, but Amber Heard did not borrow from the UK Sun. She is a uniquely situated defendant. She has personal knowledge of the issue. She's not borrowing from another publication, presumably. Presumptively, she is writing her own narrative and choosing what words go in, not going after some already published statement. A claimant should not be able to sue one publisher in one jurisdiction, lose, and sue another publisher, they didn't, regarding the exact same facts in another jurisdiction, hoping to get a better result. Now, in one jurisdiction, they filed a suit against the Sun. In the other jurisdiction, they filed suit against Amber Heard. These are distinctly different parties. While there may be exceptions to this rule, such as jurisdictions in which the rule of law is not given the same respect as that of our Commonwealth, here Mr. Depp got a second bite at the apple. Nope. On the very same facts upon which he had already lost the case in the UK. What is more galling is that Mr. Depp was the one who filed the UK action. He was the one who chose to litigate the case first, relying on more favorable standard of review. When he lost in the UK, that decision should have shut down any further actions based upon the same facts. Based upon the same facts, not quite, by the way, because the UK action is based upon the publication by a third party, but more importantly, not based on the same law. Conclusion. The trial in this case was not about defamatory statements made by Heard within her op-ed itself, but was rather a vendetta for all the publicity surrounding the allegations of abuse by Mr. Depp from the date that Miss Heard sought and obtained a restraining order in May 2016 to December 2018, or December 18, 2018. Yes, I will agree with this statement. It's also valid. This isn't a winning argument. A defamation lawsuit based on this op-ed was not a legitimate vehicle for remedying Mr. Depp's dissatisfaction with how his career is developed. Why? How his marriage ended. Why? And the negative publicity he has received, much of it warranted by his own actions, as evidence excluded would have shown. He cannot seek retribution for the allegations that were made in the California courts regarding the alleged physical abuse of Miss Heard. Why? Their divorce and subsequent publicity from various venues, including the Sun. Defamation by implication is a limited doctrine, does not allow a litigant to rehash dissatisfaction with his public coverage from years ago and from all sources. The doctrine further does not allow the claimant to twist the meaning of the words in a publication that is alleged to be defamatory when evidence establishes that the defendant has a subjective basis, considering their vantage point for the statements they have made. Actual malice cannot reasonably be found. So they're saying that since Johnny Depp is a slut, he can't be a man-ho. I mean, long and fucking short, that's what they're saying. The damage that will be done if the verdict is upheld to the First Amendment jurisprudence, the ability of Virginians to express their opinions, the ability of women to report domestic violence for fear of retribution, an expensive lawsuit would be no less than catastrophic. For these reasons, the amici respectfully requests Honorable Court reverse the judgment against Ms. Heard with instructions to dismiss all of Mr. Depp's claims. Not once in the entire fucking document did they mention the actual standard. The standard is no reasonable jury could have come to this conclusion. That's the standard. They didn't announce it once. They didn't say it once in the document. The other commentators are right. This is for mass media. This is not for court. If it was for court, they would have focused on the legal issue. They didn't do that. The legal issues are obvious in this case. You have a jury verdict. You go to the one legal issue that gets the jury verdict overturned.
So pour out an ardbeg, a bow, more a love broke. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear lost painting tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we